you. Let me get this up. All right, so just a sort of to start things off, a lot of these lessons and a lot of these tips come from having dealt with these cases for 16 years. So if you're newer to this area or don't do these cases exclusively, some of these things may not have come up, or you may not have thought of this particular solution beforehand. But most of these came from mistakes, of course, that have happened over the years. So Terry asked if I would go over the common issues that we see, common conflicts that we see in guardianship cases, and how to go about solving those issues. So probably the most common thing that we see is Family Feud. And it's not the fun kind of video show that we've seen before. It is family members that continue the feud that has little or nothing to do with the ward. And I've seen it many times where they want to continue to fight their little petty battles, and they want to use the ward's money to do it. So I'm going to give you an example of one that I had, and we finally, I think, solved the issue in this. But the first time I was introduced to this case was shortly after I took the bench. And this was the very first thing that I saw when this case came up. This is the exhibit that they gave to me of all of the financial accounts that mom and dad had, and their two children were involved in their care. The guardianship case had actually been transferred from, I believe, Bexar County to us. And you can see just the way the financials are done. It was just a very complicated case from the beginning, so what could possibly go wrong when you have this kind of setup? Well, as you can probably guess, the two sons did not get along at all, and argued throughout this entire case. We thought we had it settled at one point with a Rule 11 agreement that they had come up with, and then they never followed through with any of what they were supposed to do as part of the Rule 11 agreement. So this case just sort of kept going on and on and on. And we learned a lot from this case, and really have used a lot of the principles from this case in how we handle any of our family conflict type cases going forward. So the first thing I would say is, once you start the case and you have an ad litem in place, have the ad litem check to see if the proposed ward has signed a designation of guardian, or if there is a power of attorney. Sometimes it's just dumb luck. We've had it happen before where I appointed an ad litem, and we had no idea that there were any planning documents out there. And lo and behold, the ad litem was the one who had prepared that particular ward's planning documents many, many years ago. And we would not have known that if we just hadn't, luckily, appointed that attorney to look into the issue. So first thing, we always want to try to stick with what the ward wants. And if they have had the foresight to make a designation or put a power of attorney in place, then obviously we want to try to accommodate that if we can. The next big thing is to stop and really read the file. Again, the case that I started off with, it was a transfer case. So there was more information than you would have in just a case starting out cold coming to you. But if you stop and really read through the file, you can pick up on the conflict usually pretty quickly. And then, as I showed you in that first exhibit, that was what was handed to me. And I did not come from a guardianship background. I did not come from an accounting background. And that was just information overload for me. So put the information in a format that you understand, because that exhibit made sense to that attorney, of course, but it really didn't help me all that much. And that's where you can go to the next point here, ask for help. If you are just in way over your head and you can't figure it out, ask another judge, email somebody from TGA, hey, have you ever come in contact with something like this? Or I don't understand this, can you help me? I found people that I've reached out to have always been super helpful and very ready to jump out there and help you try to solve your problem. So if you're still having issues with the case, ask for help, and my contact information will be at the end, and you're always welcome to contact me as well. And then finally, don't assume that the attorneys who are representing the litigants in the case are going to do what they're supposed to do. In this particular case, that really didn't happen, and I'll go into that a little bit more in just a moment. So the attorneys need to make sure that it is actually the attorney who is in control of the case and not the client. I understand attorneys have to go by what their clients want them to do. But the bottom line is, it is the attorney's reputation and it's their bar card on the line if something is stepping over the line. So you need to make sure that if you're the attorney, that you have control of the case and not let the client totally drive the bus on this. And then finally, of course, the buck stops with the judge, and the judges need to make sure that you're really in control, because these cases can spiral out of control really quickly. And you have to make sure that you keep control of the case. And that can be really hard when you are a general jurisdiction judge, or for those of you who appear in different courts, if you have a general jurisdiction court that you're appearing in front of, it can be much harder. There are a lot more obstacles to try to keep control of the cases. I'm a general jurisdiction court, and about 2 minutes before I had to be on this Zoom, I was sending a jury out to deliberate in a criminal case. And that's not uncommon for general jurisdictions to hear family law, criminal law, guardianship, all in the same day. And it's easy to just get overwhelmed. So probably the biggest takeaway that I will tell for the judges for that, or for the attorneys to suggest, is when you're having a hearing, go ahead and ask, hey, judge, can we have another setting in 30 days, 45 days, 60 days, whatever it is that you might need to keep that case moving? Because I suspect a lot of times the attorneys are not any more thrilled to continue to have to deal with these clients that are complaining just for complaint's sake. And there are valid complaints too, don't get me wrong. But we all know that there are cases where you just have folks that are never going to get along, and they're going to complain for complaint's sake. So that can be a way for everybody to keep better control of the case, is before you leave that hearing, make sure that you have another hearing set. That's something that Terry sort of taught us when we came here, and now it's kind of a duh, why didn't we do that all along? But it just makes sure your cases don't become out of sight, out of mind, which I think is a lot easier to have that happen now than when we had physical files sitting on our desks staring us in the face. Now that everything, at least for us, is digital, it's much easier. Once you're done with that case, you click out of it and you forget that gosh, I needed to follow up on that in 30 days. Even for the court, if it's just a tickler reminder where it's not an actual hearing, but you need to pull that case in 30 days to see if something that you've ordered has happened, then you can do that. And we just have certain settings that we know are sort of just for us, where it's no notices need to be sent. But that is another way to sort of keep the case moving. Just make sure that there is something else on the books so that it doesn't just get lost in the sea of other cases. So when I talk about the court controlling the cases, what exactly do I mean? Local rules. We have local rules of administration that we have with all 5 of our 3 district courts and 2 county courts at law that govern civil, criminal cases. But we also have here our own internal rules that we have put into place for guardianship and probate cases. And they're very detailed, and they may even be more detailed than what some of the attorneys would like to see, because we even get into their billing rates and what we will and we won't approve. But local rules and administrative orders, those are probably the 2 big ones that can really help keep control of the case. So for administrative orders, for example, and I think I've got a slide of this later on, but we have an administrative order that we put into place for guardianship cases, that when a guardianship case is filed, you have to deposit $500 into the registry of the court, and that is for the payment of the ad litem, to go towards the ad litem's payment. If it's a run-of-the-mill guardianship case where there's no contest, there's no real issue, then $500 may well be what the ad litem gets paid in the case. If there's a contest, we also require that each contestant file the $500 within the registry of the court. We've started doing that more recently as we've seen how things sort of evolve. So those are probably the 2 biggest things that you can do as a court to keep control. And then, of course, it's always important, if you are appearing as either the guardian or as the attorney, that you know whether or not there are local rules or administrative orders in place. Our local rules are on our website, and I would urge courts that if you have local rules, administrative rules, things like that, to go ahead and put those on your website so that everybody knows what the rules are. And a lot of attorneys travel from county to county, and the rules may be different here than they are in Dallas County, and probably are. So I like having those on our website so that that can be an easy check. Also, what we did when we first started with doing the local rules specifically for guardianship, I also emailed those out to the attorneys, at least in my area, that I know usually handle guardianship cases, just as an extra heads up, so that they would know that that was out there, because it was a new thing that we were doing. The administrative orders we do not have on our website yet, but that is something that I am wanting to get on our website so that everybody can see those. Our clerk's office is aware of those administrative orders, and so when someone comes in to file a guardianship case or some other cases as well, they know that to prompt the party, hey, we need $500 to put into the registry of the court. The next thing that you can use, and I had not seen used in guardianship cases until fairly recently, are scheduling orders. Normally where I've seen scheduling orders are in family law cases, but a lot of times when you have these high conflict family situations, it is almost like having a family law case. So a scheduling order can be great to tell everybody what's going to happen when, and if you don't have your experts designated by a certain time, then you're not going to have experts. And then to follow up, sort of the natural thing to go behind that would be mediation. We have started using mediation, and it has been very successful in our guardianship cases. Now, you don't want to use just any old mediator because, as we all know, guardianship cases are very unique. They have their own rules. Everything is a little bit different in guardianship cases. So TGA has a mediation course specifically for guardianships. And so we like to make sure that unless it is an attorney who has predominantly practiced in the guardianship or probate area and is familiar with the estates code, or we've also used retired statutory probate court judges. If it's not one of those two, then we look for that mediation to see, because we want someone who understands the ins and outs of guardianship cases specifically. Another way that you can really control these cases are deposits for cost. The Estates Code allows us to order the litigants to put money into the registry of the court as deposits for the costs that may be incurred. So especially if you have one of these high conflict cases, it works really well. And I'm going to talk a little bit more about that on the next slide. And then, as I said, the easiest thing to do if you're general jurisdiction and you don't have time to do all of this, the other things, set a hearing before you leave the current hearing. So deposits for cost, that's controlled by the Estates Code, section 1053.052. And that's the code that allows the courts to require this deposits for costs. So why it's important is the ward's estate doesn't need to be diminished by fighting in the family. A lot of these issues will be couched to the court as, you know, these are issues involving the ward, but once you really sit and look at it, it can just be times where the ward's money is being used to fight amongst the family. And so having people put up the deposits for cost lets the case continue without having the ward's estate being diminished. The taxpayers shouldn't have to foot the bill. So it also lets the costs be allocated to those who are actually fighting the contest. And probably most importantly, it lets the parties sit back and decide if all this fighting is really worth it. In the case that I referenced at the very beginning with the exhibit, I ordered each one of those litigants, the two kids, to deposit $30,000 into the registry of the court because it was just continual bickering back and forth, fighting on and off. And I believe it was 30,000 each. It may have been 30 total, but a significant amount of money. And the reason that worked so well is I did not want a parent's money to be going to pay for these two fighting. And I told them that. I said, y'all can keep fighting all you want, but your parent's not going to pay for it. So that was one of the things I think that really helped close out that case. And if there is a true need for a contest, it lets everybody focus on what the actual issues are in the contest and not get caught off in the weeds. So it helps focus the case more on the guardianship and not on the family infighting. So the next thing is ongoing custody disputes. If you have a case where a minor has reached 18 and the parents are continuing to fight their custody dispute now through a guardianship case, we have seen that issue come up. So unless you have a family law attorney, and a lot of times we don't even have attorneys who are involved in the final decree of divorce. So, but unless you have somebody who is involved, who first of all knows that there's a child with a disability involved, that's not always even brought up before the court. But if you have someone who knows the family code and knows that they can provide for visitation and for child support after the child turns 18, then that's where you end up having the continuation of a custody case and a guardianship case. So the family code actually addresses that a child support order can be entered as part of the divorce decree, that if a child is disabled, as is defined under that section in the family code, that child support can continue for an indefinite period of time. So that is something that if you handle different types of cases, that's always something that's good to know. And then also the family code says that the family court can issue an order for possession and access to an adult disabled child that's appropriate under the circumstances. And it can be enforced under Chapter 157 for a motion for enforcement in a family law case. And something like this may alleviate the need for a guardianship. It may not, but it can put a lot of the issues in front of the family court if it's truly just fighting over the custody and visitation and child support of the now 18-year-old child. And the family court will retain continuing exclusive jurisdiction of that case. But the probate court can still exercise guardianship jurisdiction if that becomes necessary. So if you do have a case come up where it is a continuing custody case, and they bring it to you as a guardianship issue, then if possible, appoint an attorney ad litem that's familiar with both guardianship law and family law. People will keep referring back to the divorce decree and what happened during the divorce, and it just makes it easier if you have somebody who speaks both languages, so to speak. And then you may also want to appoint a guardian ad litem in addition to an attorney ad litem, sort of like having an amicus in a family law case. It can just give you a better idea of what's actually going on in the case and what is actually best for the proposed ward in that case. And then finally, mediation. Just as it helps in family law cases, it can be very, very beneficial in guardianship cases as well that involve family disputes. The next big issue that we see is you have family that is unwilling or unable to help. So when you don't have a family that can come in and help, or they're just not in a position to be able to help, then you can look to other people to appoint as a guardian in the case. That may be friends, it may be distant family, it may be a private professional guardian or a guardianship program, or if you don't have any of those things, sort of what we've started using as more of a last resort are attorneys. And attorneys mean well, but they're not necessarily in the best position to be acting as a guardian in a case. It's a lot more intensive, or can be, than just acting as the attorney in the case. And sometimes they just don't have the staff or the time to be able to devote to be a guardian in a case. And typically an attorney has different focuses than what a guardian would have. So when you have a guardian ad litem in place, that may be someone who can go in and help locate at someone who may be an appropriate guardian for you. Probably the biggest challenge that you will have if you're in a smaller county is who's going to pay for this. That's what the commissioners and the county judge are going to be asking you. And so I would really encourage you to have a conversation with your county judge and your county commissioners. If you are the attorneys or the guardians, consider saying, hey, judge, I'll be happy to go with you to have that conversation with your county judge or the county commissioners and tell them why it is important that we have some resources to be able to compensate a guardian when family is not an option. Because we all know that there are a significant number of cases where that can happen. And primarily where I see those types of cases are mental health. In mental health, oftentimes we get cases where family has washed their hands of the individual who is needing assistance. And anyone who has ever dealt with any case where mental health is an issue, they're difficult cases. They just are by the nature of them. They're difficult cases because a lot of times when they come to you, that can be when a proposed ward is very deep in their mental illness, and it makes it very difficult. They're just not the resources out there that really there need to be, and I don't think I'm shocking anybody by saying that. We in Brazos County, we used to have a hospital here, and we did a lot of our mental health hearings for that particular facility. They have since closed up shop, and we don't have a local mental health hospital anymore. So if we have folks that really need to have that inpatient treatment, of course, that cannot be ordered through the guardianship case. That has to be a separate mental health proceeding. But Brazos County, like many other smaller counties, we just don't have those resources. So that's just one of the things that makes these types of cases difficult. The other thing is, even if you decide to establish a guardianship, is that guardianship really going to be beneficial to the ward in the case? That's one of the things that we struggle the most with the mental health cases, is making sure that there is, Terry always refers to it as a good therapeutic relationship, whether this guardianship is really doing anybody any good. And this is where we see probably the highest failure rate is in our mental health cases. So what we try to do is we try to clarify with the ward from the very beginning that they're going to have to cooperate to make this guardianship case work. And if you have someone who is not on medication and is refusing medication, and so they are very deep into their mental illness, it can be very difficult to get their cooperation. So that's one problem. The next problem is even if you do get an agreement from the ward that yes, that they're going to be not a hindrance in the case with the guardian, then it can be very difficult to find a placement for them, someplace where they can safely live. Lots of times we have folks who are either already out on the street or who are in a bad living environment already to begin with, and that can be one of the difficult things as well. So as I said, the best chance for success is getting the wards agreement, talking to them, trying to get them to understand that they need to be cooperative with the guardian in the case in order for this to work. Also, you need to get MHMR and or a private physician that maybe they already have a relationship with involved in the beginning. MHMR, having a good relationship with them is crucial to being able to get services in place that will assist with these guardianship cases. And to that end, it really makes it easier if everybody has sort of met and put a plan together before you have the actual hearing, so that there is a plan in place at the beginning of the guardianship to get the case going in the right direction from the beginning. In these cases, we've found if they are not set on the right course in the beginning, it's very hard, if not impossible, for us to get it back on track. So we try to sort of have a game plan in place with MHMR at the beginning so that we can steer these cases hopefully in the right direction. And then one way to do that also, besides getting the proposed wards agreement that yes, they'll cooperate, include them in the planning as much as possible. Just as with any type of decision, with any adult, they're going to want to say so. And so if you can get them involved as much as possible in the planning, that can help increase their compliance. Appoint an ad litem that's compassionate and can help the proposed guardian. And I've got a good example of that in just a moment. And what we do is we start with a temporary guardianship. Temporary guardianships can be in place for 60 days unless there's a contest, in which case they can be in place until the contest is resolved. But the temporary guardianship, we found if we can't get it pointing in the right direction within 60 days, we're probably not going to be successful in that case. So I told you, I have an example of appointing an ad litem that's compassionate and can help out the proposed guardian is something that we pretty much consider essential in these mental health cases. And so I just want to give you a brief story of one of the cases that we had that was a positive. So I'm going to tell you about Holly. This is the inside of Holly's apartment. I was introduced to Holly when she was getting ready to get evicted from her apartment. She lived in the apartment with her mother. Her mother had the only source of funding for the apartment. She was the only one receiving any money. And so APS came in and looked at the situation and took her mother out of the apartment, but left Holly. And Holly had has schizophrenia. She had some wounds on her legs that we were even afraid for a while that her legs may have to be amputated, that they were so bad. But you can see this was a bad situation. And I had a very experienced peace officer who was a constable who was going to go out and serve the eviction. And he saw me and came over to me and he said, it would honestly be kinder if I shot her rather than put her out on the streets, because she will die and it will be slow. And so for him to make such a bold assertion and tell me what was going on in the case, he said, I don't know what to do. And I said, well, you hand it to me. And so we took that case and we ran with it. And we appointed one of our local attorneys as the ad litem, who is super compassionate, handles guardianship cases, and he was able to find a placement short-term in a nursing home to get Holly's health back up to speed and to get her back on her medication. Through his intervention, he was able to help get her physical wounds cleared up. And today, this was in 2017, I believe. Today, Holly is living on her own. She has her own apartment. She is back to going to Blinn Community College and is living a great life. She's still under guardianship. And just a side note, that ad litem, the attorney, he still visits with Holly. She, in fact, has become like a part of his family. He and his wife have her over on holidays and even give her a little bit of money each month to help with her spending. So that is a true success story. And Holly didn't have any other family that could assist, and there were no friends. It was actually this constable who was going to have to evict her, and the apartment management who was trying to help her out that got us involved with it. So that is our best success story that we have had with mental health cases. Now, in contrast, we've had a case with a gentleman, I'm just going to give his initials as DS. He has had a long history of mental illness, again, schizophrenia. All three of these folks that I'm going to talk about are have schizophrenia. And although the family initially called us because they needed assistance, he was violent. He punched holes in the walls of the house. He was destroying the house. He had shot a neighbor with a BB gun. He'd been to Ash multiple times. And he's currently sitting in our jail right now for aggravated assault with a deadly weapon against his dad, where he pulled allegedly a knife on his father. But in that case, we tried with third-party guardians to get different placements. We actually had him placed outside of the county. His mother was a textbook enabler, and she really torpedoed our efforts at every turn, to the point where he was leaving the placement that we had for him, and which was several hundred miles away, and attempting to walk home on the highway, and that's where he would get picked up at night. So we finally had to terminate that guardianship because we were being undermined by the family at every turn, and it wasn't safe for us to continue with that guardianship. We didn't want something to happen to him on his way trying to get back home to mom. And it was just a bad situation. And although we haven't been involved with it in the guardianship aspect, obviously it's still not a great situation if he is still in jail, and has been for quite a while now. And then another one that we did not have success with was EW, and she has a long history of mental health issues, is in and out of our jail. She actually physically removed one of her eyes, and so we were trying to get her into a better place. Her home has holes in the floor that EMS has to come pull her out of. And by the way, before you ask, in both of these situations, APS has been contacted and HHSC, and that did not help the situation. So these cases are difficult, as I said, because family may have washed their hands, or they may be contributing to the destructive behavior, even when we were able to get a third-party guardian put into place. And the nature of just the mental illness and housing issues are the big impediments to these types of cases. And then taking advantage of the ward's financial situation. The best way to control these cases, thoroughly review your annual accounts. We actually have forms now, so that we're trying to get our annual accounts in the same format for everybody so that we can better manage these cases, because nobody's ever going to say, oh yeah, I'm taking a little bit extra from somebody's account. It's going to be hidden in there. So if we have a set form, it helps us be able to sort through the cases better and to get a better grasp on it. So things to look for: is the money being spent, does that correlate with the financial status of the ward? In other words, are there these huge expenditures when they have a monthly income from SSI? If those two things don't correlate, then that needs to be looked at. Is the guardian seeking court approval prior to reimbursing the guardian themselves or to paying others? And yes, that includes attorney fees. There should be a court order to for any money coming out of that guardianship before the money leaves the guardianship, with one caveat: if there is an emergent need. We've had that happen before, where something happened at a house and an air conditioner quit working and had to get in and get that air conditioner replaced when it was 105 outside. Obviously, that's something that everybody understands. And then finally, to look what the reimbursement is really for. So guardianships of the person, as everybody knows, the estates code governs what has to be in there, but just a couple of things to point out. The reports can only cover a 12-month period, and that period begins on the qualification date. The court can alter that reporting period. We have had some asked to go on a fiscal year and some asked to go on a calendar year, just to make things easier for that particular guardian, and that's fine, but the report still cannot go longer than 12 months. So you may have a 12-month report and then a 4-month report, and then start over again with another 12-month report on the new reporting cycle. And the report is due no later than 60 days after the date the reporting period ends. A guardian can file these reports themselves. They do not need to have an attorney. And yes, we have a form for that on our website that they can download and fill out. No annual report means no letters of guardianship. So that's usually the best sort of leverage that we have to keep these cases going. What should the annual reports include? The living arrangements. Are they good living arrangements, or do we need to be looking for something else? The current physical and mental condition of the ward, who is controlling the income and the estate, if there is one. Are there any unmet needs? Does somebody need a wheelchair ramp to get into their house that we may be able to get some volunteers to go over and help build, because they're having difficulty getting in and out of their house? And then a statement regarding whether or not that guardianship should continue, and that the Bill of Rights has been given and explained to the ward each year under the guardianship. We found that pretty much universally people tell you, yep, this guardianship should be continued. If there's a way you can actually talk to the guardians themselves each year. It was amazing when we got Terry involved in our guardianship cases, and we could bring the wards in, and a lot of them said, oh yeah, I just said that because I didn't, we don't really need it, but that's what we've always done, so we're going to keep doing it. So if you can talk to people, even if it's not every year, even if it's every other year, and just sort of schedule these little conferences for people to come in, have the guardian and the ward come in, talk to them, and see. That's when we found out a lot of these cases could be scaled back. Maybe we needed a new CME, or maybe there didn't need to be a guardianship at all. So for the courts, we always look, did the ward move? It's amazing how many times the ward moves during a reporting period and nobody told us. Or that one of the guardians, if you have co-guardians of the person, mom and dad, and one of the parents has died. Well, we need to redo that so that we only have one person who is the guardian, and just get that cleared up. So that we know who is actually in the case. Do we need a new CME? We've started pretty regularly requiring new CMEs because we have found that even in cases where we didn't think things were going to change, things have changed. Make sure that you have the current contact information for the guardian and the ward. We would have difficulty sometimes finding people, and so this regularly having it in the annual report really helps keep track of that. And if the guardian is elderly, if you have parents, say, who are the guardians of their adult child, then and they're getting up into their late 70s or 80s, then it's time to have that uncomfortable conversation with them about, all right, so what's going to happen if you become ill or pass away? Who is willing to step up in your family to take that position? And we've also had times where we've talked to the guardian and they've said, you know what, I'm ready for that to happen now. And we get, say, a sibling in place. And then finally, for the courts, if you provide the blank forms, like I said, on your website, that makes it that much easier for the guardians to file those on time each year. So what happens if they don't file their annual report? We send out a postcard ahead of time and remind them. Again, I know a lot of courts don't have that capacity to do that. We're very fortunate, but what we used to do before we had that ability is I would send out a letter that said, hey, you're supposed to file this annual report. If you don't file it within the next 30 days, then you're going to need to come to court and you're going to need to tell me why you should still be the guardian and why I shouldn't fine you. Because those are the consequences that the court has available if someone does not file their annual report. And then, of course, the ultimate sort of sanction would be to revoke the letters of guardianship. So important takeaways for all of these situations. As a third-party guardian, so if you were stepping in as a third-party guardian of someone's estate, secure the assets as soon as possible. That means change the locks on the house. Make sure that you're the only one that has the ability to get in and out of that house, especially if that's not where the ward is still living. Obviously, if the ward is still living there, then there's some other people who need to have access. But I have been called on a Friday evening from actually a judge who lived across the street from one of my guardianships wards. And the family was coming with pickup trucks and cleaning out the house. And I get this phone call at 10 o'clock at night that says, is her family supposed to be coming and looting her property? And so that is an important thing to have happen, is to make sure that those sorts of things are not happening. If you're the guardian, go through the actual house, look through the items in the house. That same case, we found out later after the house was sold that there were documents about other investment accounts that were thrown away because the new owners of the house assumed or had been told that the ward had died. And so they threw them away. They didn't have any use for them. All of the contents were still in the house when they were sold. According to the inventory, it was very minimal value of the items in the house, and that was not the case. There was an auctioneer came in and took all that property and sold it, and that money went to the new owners of the house because it was then their property. So if you're thinking about selling the items, consider having the items appraised. Some of that stuff can be really valuable, even if it doesn't appear to be on the surface of it. So if you're not well versed in that area, you may have somebody that you need to do with that. Don't just abandon the property unless it's more expensive to keep the property than it is to actually abandon the property. And make sure the property is insured. Do a thorough inventory. As I said, when you have property that's $200, is what was represented to us was the value of the property in the house. And I later learned that no, that property was sold for much more than that by the auctioneer. That doesn't make me very happy, that those funds could have been used for the ward. And then finally, make sure your bond is adequate so that that protection is there for the estate. So decisions that you may have as third-party guardian of the person that may require court approval, just to throw these in there. We've only had one of these happen, but sterilization, abortion, experimental procedures, removal from life support, or talking to the ward about any sexual interactions. That's the one that we've had. And yes, that's very uncomfortable for everybody to be talking about that in a courtroom, but it is important. And finally, just to reiterate, the guardian can never consent to inpatient psychiatric treatment. That can only be done by a separate mental health proceeding. And I cannot tell you the number of times I've had attorneys who don't normally deal with guardianship cases come to me and say, oh, we need this guardianship so we can commit this person to a psych hospital. No, no, it's just not going to work. So as the attorney, make sure your clients know the rules. We have all of our rules again on our website. Go through those, and you may have rules of your own that you have that you want to give out to your clients, but give those rules to them so that they know up front and they're not floundering. Guide your clients' decisions. And make sure that they understand that they are acting in a fiduciary capacity and they're not just helping out. They're just not just acting as son, daughter, cousin, friend anymore. There's actually a fiduciary duty there. And finally, it's not your client's money that they're dealing with. Things that they may have considered reasonable to them may not be what are reasonable under a guardianship case for the money to be spent on. So practically speaking, for the attorneys, the best way to do that is to have the guardian establish an annual monthly budget that is approved by the court from the outset. Then you don't have to keep coming for that mother may I spend this money every single month or all the time. You already have it set out. So as long as the expenses are within a certain parameter, they're basically pre-approved. So the everyday living expenses. And that's especially helpful if you have a ward that is living independently, and the budget can be amended as needed. As living expenses go up, maybe they need someone to come in and help with different situations that they didn't have to have before, so they need a paid caregiver come in, then that budget can be adjusted. Attorney fees should be approved before the guardian pays them. It's okay for the attorney to send out, hey, this is what the bill is going to be, but we got to get court approval for that first. And also make sure that the guardian's aware not to commingle their money with the money of the ward, which again, if you have a close familial relationship, that can be an issue. And finally, the last one, this is my rule, no cash withdrawals. Cash withdrawals seem innocuous enough until you look back over 5 years of cash withdrawals and somebody's been getting out $50 here, $100 here, and it may not seem like that big of a deal, but once you see, oh wait, that's several $1,000s that's been going out over a longer period of time. So I've just started telling people no cash withdrawals. I don't want to see them. So for the courts, when you're getting cases, if Adult Protective Services was involved at any point, make sure that the records you are getting are unredacted. They will always, at least with us, try to send us the redacted records, and that's not much help to us. We need to know everything that's going on. In your court orders, be specific. Have specific timelines in there about when you want the house to be secured, how many days after qualifying you expect this, that, or the other to happen. The more specific you are, the easier it is to guide things and to control the case. Make sure that the bond is adequate at the start and after each annual accounting is reviewed. Every now and again, you have somebody who comes into this great windfall for whatever reason. Maybe they sold their house and the housing market is really up like it is now. And they all of a sudden have this infusion of $500,000 into their accounts. That needs to be compensated for with the bond. And if there's a third-party guardian and maybe you have family members that are in conflict, so you've removed that conflict by having a third party put in place, we try to get everybody to sign off on the guardian's orders before they're filed so that we know that everybody knows what's going on. So one sibling or family member can't come back later on and say, oh, well, that was just pushed through and I didn't know anything about it. So that can potentially help conflicts in the future. If the case is a case that's being transferred, it's easiest if you can get waivers from the guardian of the and of the sureties to expedite the transfer and to save on the costs and the challenges of personal citation when you're going to be transferring a case. Have as much information as you can available to the public and to use those orders that I talked about in the very beginning. And just for those of you for the court for setting bonds, rule of thumb is the value of the personal property plus anticipated revenue for 1 year plus 10% should be the amount of the bond. So the biggest takeaway is that to remember that guardianship can be a useful tool to assist people, but you are signing, the court is signing an order to take away somebody's rights. And we're trying to help someone live their best life. And so we want to make sure that they are protected as well. So it's always useful, even when these cases get into the weeds, to kind of take a step back and remember why you're doing these guardianship cases. And so if you all ever have any questions, you are, as I said, welcome to call, email, or poach any of the forms off of our website. Or if you need any of those forms emailed to you in a different format, if I have it, I'm happy to do that as well.
Well, thank you, Judge. I know you've got a jury out right now. Do you have a minute or two to answer questions if somebody has one?
Sure.
All right. So those of you who are here on the webinar, this is your chance to ask a question of a judge without being laughed at or sanctioned. So any questions that you have, this is the time to ask them. All right, good. All right. Thanks for the fantastic presentation. No longer called MHMRA. What is the new name? I don't recall. Good point. I don't know necessarily the new name for MHMR either, but I think it may depend on the jurisdiction. They can be called different things in different places. All right. Lots of well wishes, Judge, and thanks. Any other substantive questions that you'd like to ask Judge Matzke while you have her here? Judge, I think that one thing that I'd like to note, and I know that some of our attendees here in statutory probate courts, a lot of them aren't. What you've done in Brazos County is kind of create a little micro guardianship system with the county having a contract with a third-party guardianship provider for indigent cases and some court staff and that kind of thing. Can you just touch on your view of life before you had the additional resources and after, just so those that don't really have a good system in place maybe can get some advice on how to do that.
Well, if you'd asked me in 2016, the year before you came to Brazos County, I would have said, "Oh no, we're handling them pretty well. I think we're doing okay." And then it took about a year for you to go through all of those initial cases and get everything in the right posture. And Judge Locke and I found out we didn't know what we didn't know. We had assumed that everything was rocking along just fine. And from what we saw, it was. But the truth was, we did not have the ability to keep up with the cases like pretty much every court, I think, that does not have a Terry. You just can't keep up with everything. So now I think we're in a much better position. I used to tell the commissioners and the county judge that, this is the only area of law where judges can be held personally liable. So I want to send my kids to college, and I don't ever want there to be the need for anything like that anyway. I want to do what's best for all of these cases, and I think everybody does. So they finally agreed that we could, instead of paying for a higher bond or insurance or anything like that, we came up with Terry's position. And so he is now our insurance policy that we have in place. And I mean, it's a lot of work, Terry, and now he has an assistant, Krista, who helps him. And they are constantly going, and I'm constantly getting things in guardianship cases where you may have thought it would alleviate some of that. I actually probably get more from guardianship cases now than I did before, but that's a good thing because there are things happening and things being structured correctly the way things need to happen.
Thank you. We have a question about talking about case staffings, countywide case staffings with kind of principal players in the community.
Right. So before COVID, we were trying to do that. I think we were about every other month, maybe every third month. And we would bring in MHMR. That was back when we had our mental health facility here, our officers that did mental health cases, all came to that meeting, some attorneys who did a lot of guardianship cases. And that was really helpful to sort of find out what was going on in the community and what may be coming our way, and to sort of give everybody a heads up. So especially people who are the boots on the ground, the folks at MHMR and the mental health officers could start to try to put a plan in place, and those discussions started so that we could help people better from the start.
We would do those kinds of case staffings when I was practicing out in El Paso, and it's really part of the court and the practitioners being a part of the community and working with the community to come up with solutions in difficult situations. And it was always surprising when people come together, whether it's from the police department or the county sheriff or the mental health authority, whoever it may be, that everyone has had some interaction very frequently with the person who's come before the court in a difficult case, especially the difficult mental health cases. So thank you for that question.